Hello, everybody. This is Advocate Lucinda, your empowerment lawyer. Well, I have had individuals contact me and they have a problem with what do I do next? Well, you want to watch this video because we are going to discuss steps taken after the complaint has been filed. We'll see you on the other side. One, you want to know the rules. What rules am I talking about? The Federal Rules of Civil Procedure. The Federal Rules of Civil Procedure govern civil procedure in United States District Courts. Now, if you look below, you see a link highlighted in yellow. You can download that now in case you want to look up various sections as we go through them. After the complaint is filed, what is the next step? The plaintiff must serve the summons on the defendant. Federal Rules Civil Procedure 4. Let's take a look. This is the summons form that the plaintiff completes and sends it to the defendant, notifying the defendant that he has been or she has been sued. It's pretty self-explanatory and easy to follow. The caption information, you take that from your complaint. It's going to remain the same, remember? In this blue box here, this is going to go to the defendant, include the defendant's name and address. And you can read this information. But the answer or motion must be served on the plaintiff or plaintiff's attorney whose name and address are. Now, if you're pro se, you need to include your information, okay? And you can read on. And of course, it's dated and is signed by the clerk. Now, however many defendants you have, you need to complete that same number of summons, okay? You need to serve them individually. We're speaking of multiple defendants. They need to have their own summons. Now, once the complaint has been served, then the person serving the complaint on the defendant just has to show that he or she completed service, and this form is completed as a result. Okay? Now, the plaintiff has 90 days to serve the complaint on the defendant. Federal Rules Civil Procedure 4M. Within 21 days after being served with the summons and complaint, the defendant must answer. We saw that earlier when we were discussing the summons. Now, if the defendant is a federal government agency, the defendant has 60 days to answer the complaint. Federal Rules Civil Procedure 12A 2, and 3. Now, I said earlier that we were going to discuss 2 ways in which the defendant can be served, but I'm going to deal with 4. So, in other words, who can serve the complaint upon the defendant? Number 1, any person 18 and older who is not a party to the case or the lawsuit can serve the complaint on the defendant. In some jurisdictions, the U.S. Marshal serves the complaint on the defendant, or the Deputy U.S. Marshal can serve the complaint on the defendant. I use them both, the Marshal and the Deputy Marshal, or any person who is especially appointed by the court can serve the complaint upon the defendant. But be sure to read the local rules in your jurisdiction. Now, I want to talk about an animal that most plaintiffs don't know exists. It's called waiving service. So a plaintiff could ask the defendant to waive formal service. Formal service as summons that we just previously discussed. But asking the defendant to waive formal service cuts down costs and really time. And you'll see how. That's Federal Rule of Civil Procedure 4D. This is the notice of a lawsuit and request to waive service of a summons. This document is completed by the plaintiff, who sends it to the defendant, notifying the defendant that he or she has been sued and requesting that the defendant waive the formal service that we discussed earlier. The information is pretty self-explanatory. This is the waiver of the service of summons. This document will be returned to the plaintiff. Remember, the plaintiff sends this waiver of the service of summons to the defendant. The plaintiff should also include a copy for the defendant to sign and return with a self-addressed stamped envelope. So we start with the caption, same information, and to the plaintiff, because this is coming from the defendant to the plaintiff. And the defendant is able to complete this, put it in that self-addressed stamped envelope, and send it to the plaintiff. Simple as that. Now, let's see what happens after the complaint is served on the defendant. Federal Rule Civil Procedure 5. If you recall, when we were discussing the summons, the defendant has 21 days to answer the plaintiff's complaint. If the defendant is a government agency, then it has 60 days. Federal Rule Civil Procedure 5. The motion to dismiss. I am sure you're familiar with this. This motion is filed by the defendant almost always to get rid of the case at the front end. So while it is not an answer or a 21-day response, it is nevertheless an answer. And for those of you who just want to review the motion to dismiss, I uploaded a video some time ago. You can watch this video at the link given below. Now, what happens if the defendant does not answer the complaint at all? Well, if you recall, during our discussions of the summons, there was language in the summons to the defendant that failure to respond to the complaint could result in default against the defendant. Federal Rule Civil Procedure 55. Now, you want to check your local rules to determine whether the court would issue a default sua sponte or whether the plaintiff would be required to file a motion requesting that the court find the defendant in default. The scheduling order. Now, I call this the Big Daddy. I call it the Big Daddy is because it is the order that assists the parties in litigation. It's like a guide, a map. So once the complaint has been filed, the parties have been served, the defendant has answered, discovery is around the corner. So prior to discovery, the parties conducting discovery, a pretrial conference needs to take place between the parties, the plaintiff and the defendant. And I will show you what that looks like in real time. So the parties will get together and they will discuss various aspects of the litigation. They will complete the scheduling order. Federal Rules Civil Procedure 16. Let's look at that order and what it entails. This is a sample of the scheduling order. This document will be completed by both parties, the plaintiff and the defendant. Remember, I said earlier, or maybe I didn't, but I'll say it now, that after the parties complete the scheduling order, they're going to sign it and submit it to the judge. And the judge is going to eventually sign a scheduling order. Now, you want to check with each jurisdiction to determine what the rules are. So look at the local rules. Okay? So let's review this. So the scheduling order, date of conference, that is what the parties will be discussing. That's pretty much what the parties will address in their conference, okay? They will need to include the statement of this jurisdiction. And the parties should be familiar with this because it's already stated in the complaint. Statement of claims and defenses. Both the plaintiffs and defendants would need to include this information. undisputed facts. If the parties have facts that are not disputed, those facts would be included here. Computation of damages. That should be easy for a plaintiff who has, let's say, sued for employment discrimination, and as a result, they incurred lost income and some other damages. That should be easily calculable. Number 6, report of pre-conference discovery and meeting under Federal Rules of Civil Procedure 26. And this is what's involved in that. You want to review Federal Rules Civil Procedure 26. The date of the Rule 26F meeting, this meeting that the parties are having, that is your 26F conference. You need to state that here. Name of each participant and party that the attorney represent, or if you're pro se, your information would go here. As statement as to when Rule 26A1 disclosures were made or will be made. You need to read Rule 26A1 because there are certain disclosures that both parties need to make. So read that, and it will guide you as to what information you need to report. If a party's disclosures were not made within time provided in Federal Rules of Civil Procedure 26A1C or by the date set by court order, the parties must provide an explanation showing good cause for the omission. Hey, the court is serious about this. So just keep reading. You can answer these. I'm not going to go through each one, but I want you to see how involved the scheduling order is, because litigation is involved. Okay, so you want to be able to respond to each of these items. Okay, consent to whether you would want a magistrate judge to oversee the scheduling order. Okay, discovery limitations here. That is critical. And because I'm a plaintiff's attorney, and so many times, particularly pro se plaintiffs, they're intimidated about requesting that limits be put on discovery. For example, a plaintiff should feel free to say or object to the defendant deposing them for more than 2 days if it's not reasonable. And don't be intimidated about that. So when the parties come together, particularly pro se individuals, I want to encourage you, be bold, be respectful, but be bold about what you believe is hurting you and it is exceeding the discovery rules. Okay, but make sure that if you oppose something, make sure you can substantiate it. Okay, let's go down. Case plan and schedule. Okay, discovery cutoff. Talk about that. What do you think discovery should end? Because remember, even though discovery may end on a certain time, you could always agree to extend discovery. And even if one party doesn't want to extend discovery, but for the most part, the parties agree to that, right? Because it gives everyone additional time. But the discovery cutoff, dispositive motion deadline, that's the motion for summary judgment. You have the motion to dismiss on the front of the lawsuit. You have the motion for summary judgment at the back end of the lawsuit. Expert witness disclosure. Read the rules regarding that. And of course, read the rules before. I'm talking to the plaintiffs now. Of course, review the rules before you get with the defendant. And make sure you got a good grasp of your information. Identification of persons to be deposed. Deadline for interrogatories. That's discovery. Deadline for request for production of documents and or admissions. Dates for further conferences. For example, the defendant may want to revisit settlement if they made a settlement earlier. That information would go here. And other scheduling matters. And then, of course, the court makes its notice to counsel and pro se parties. Follow them, please. And the amendments to scheduling order. So even though a judge signs the scheduling order, you may want to put in a clause that the parties agree to amending the scheduling order if it's feasible. Right? So don't be afraid to say, yes, we may need to amend the scheduling order for whatever reason. Okay, and the judge is going to eventually sign the order after he or she meets with both parties, hammer out any differences, sign it, and now you have a plan to follow to the end of the lawsuit. Okay? Be sure to read the rules. I trust this video has been very informative and you are able to move forward in your litigation. And as always, I never like to leave without saying, be empowered.